welcome to the Global Health Impact Network Education Series. Now, our goal with these series is to take you on a journey to understand the topics we discuss in more depth. Now, today is our very first episode on a very interesting topic, which is intellectual property, which is IP. Now, if you're like me, you know hardly anything about IP. But honestly, it's a very interesting topic, and I've been amazed with how much I've learned in the past couple of months. So, over the next 6 episodes, what we will cover is in the first episode, we'll cover what is IP and how to understand IP. Second one will be what are the requirements for each form of IP? Where are you protected? Is it territorial? And then we'll move on to building IP portfolios to create company value. And then what are the costs of getting your protection and the costs of not doing so? And then I have a patent. Now, what do I do with it? So in today's episode, we'll start with what is IP and how to understand it. So, ladies and gentlemen, I would like to introduce you to a good friend and an expert in IP, Mr. Joshua Goldberg, who is co-managing partner of Nath Goldberg Meyer. Joshua, it's a real pleasure to have you here with us.
Oh, it's a real pleasure to be here, Martin. Thank you so much for inviting me.
No, you're very welcome. So before we kick off today's episode, why don't you just give a quick introduction of yourself and our firm and your firm, just so the listeners know who you are.
Sure. So as Martin mentioned, I'm Josh Goldberg, co-managing partner at Nath Goldberg Meyer. We're an IP boutique law firm in Alexandria, Virginia. For those of you who don't know what that means, it means all we do is intellectual property. We're not your tax lawyers or your family lawyers. Everything we do relates to protecting your new ideas, your IP, whatever it is you're doing to distinguish yourself from the competition. And we're very focused on the front end. How do you get your protection? How do you use that to protect your markets, protect your services, your products, and build value in the company? Because let's face it, we're all interested in building value in the company and making our companies worth as much as they possibly can be.
Exactly. So, what is IP? Like my understanding of IP, refers to the creation of the mind, like inventions, artistic works, names and images used in commons. So, I'm going to be quiet because I want the listeners to listen to you. So, why don't you just go into a bit more detail and tell us what is IP and what are the different types of IP?
Sure. So, IP as a broad concept is a way to turn something ephemeral, fleeting, into something concrete, an actual property right. So everybody understands the concept of real property. You have a house and you have a deed of land that tells you what you own, what your house is, how much property is yours. IP, intellectual property, is the same thing, but for ideas or works of art or new creations. It lets you say, I created this, I made this, I own this. Nobody else can have it unless I tell them they can share with me. And that relates to a number of different kinds of ideas that you can create. So you mentioned different forms of IP. And there are 4 main forms. So the one that everybody thinks of as something for a new technology, a new invention, is a patent. So that covers anything you're doing that represents an advancement over what's been done before. Then you have trademarks, which protect your name, your company name, your brand, your logo, not just for your company, but for any product or service you might sell. And I'll give examples of each of these as we go through, but here I'm just laying out the roadmap.
Okay.
And the third form would be copyrights. So this would be a form of artistic expression that's fixed, be it a work of art like a painting or a novel, any type of musical composition that you make, or even, a telephone book, right? Just the way all the information is arranged is something copyrightable. And then the fourth kind, which most people forget about, is trade secrets, because they're used less often than the others. And that protects any information that gives you and your company a competitive advantage that you can reasonably keep secret is subject to trade secret protection.
I didn't know that.
Yep. It's really rare, or it used to be really rare. The big thing is that can you keep it a secret or not? And a lot of things are not subject to a secret. So, by way of real world examples, and maybe I'll just jump right in here. The most valuable trade secret in the world, and this is something that everybody out there, I'm assuming, knows about, the formula for Coca-Cola, right? There is, from my understanding, there's one old yellowed piece of paper that's 100 whatever years old now that maybe 3 people in the world have access to, that this is the formula for Coca-Cola. And apparently, for whatever reason, Coca-Cola is not easily reverse engineered. If you put it in a gas chromatograph or run any kinds of testing on it, you can't find what all the different components are, all the different pieces of it. So unless you know the secret, you're not able to make Coca-Cola. And anybody who's tried Pepsi Cola, RC Cola, anything else knows, yeah, they taste different. They're not identical. If somebody else found the formula for Coca-Cola, boy, would that be worth a whole lot of money. So getting back to some of the others, trademarks, Coca-Cola is another one that has a really valuable trademark, right? If you think about the stylized lettering for Coca-Cola, the white lettering in script, or the white with red on the background, even the name Coca-Cola by itself, that's a registered trademark. I'm old enough, I'm a child of the 1980s. I remember it used to be you'd go to a restaurant, and if you wanted a drink, the waitress would say, "Hey, what would you like to drink?" "I'll have a Coke." And she'd go off and she'd come back with some brown cola flavored beverage. And it might be a Coke, it might be a Pepsi, it might be something else. It didn't really matter so much. But sometime in the late 1980s, early 1990s, that started to shift. And you'd go to a restaurant and you'd ask for a Coke, and you might hear, "We don't have Coke. Is Pepsi okay?" And that's because of a trademark issue where Coca-Cola was very worried that they were going to lose their trademark rights, that it would be diluted. So that if you were asking for a Coca-Cola, you got any old cola, the value of their brand, the source of their goods, would be diluted to where maybe it was just generic and there was no trademark anymore. So they actually sent people out to all different restaurants, diners, Burger Kings, what have you, throughout the country, the US. And if they asked for a Coke and they got something else, they would cause problems for the restaurant, saying, "Hey, you're diluting our trademark. You have to stop, or else we're going to sue you." So restaurants, understandably, did not want to be sued. They changed their practice to where even now today, if you go to a restaurant and ask for a Coke, you're going to be told, "Hey, we only have Pepsi. Is that okay?" Every single time.
I didn't know that.
Yep, absolutely. It's really interesting. Some specific examples of the other types of IP. So copyrights, if you think any type of sound recording, right? Back in the days when there were actual physical media that we consumed. You had your cassette tape or your CD. All the songs on there were copyrighted. Everybody hears about now Spotify and how much money each artist gets from each play of their song. The reason that they get that amount, whatever it is, however many cents or what have you, is because it's a copyrighted song that they have then licensed the copyright to, one of the big copyright clearinghouses in the music industry. And now every time Spotify plays it, because they have a license to that copyright, they have to pay something for it. It works the same way. Think of Harry Potter. How much money has J.K. Rowling made? That's because she's copyrighted her novels, right? Nobody else can steal them and take her sales from her. If you want to read the Harry Potter book, you have to read the one written by J.K. Rowling, which is protected. So that's copyright. And then patents to me is the easiest of all to understand because it's a new invention, a new technology. But it's not just a new groundbreaking technology. Everybody thinks about the iPhone, right? If you invent something, it has to be groundbreaking like your iPhone. It doesn't have to be groundbreaking like that. It can be something simple, like, if you have a new pen. I ask people all the time when I give seminars like this, hold up my pen. How many different inventions do you think are embodied in this object?
Just a one.
I would say there are probably over 100 different inventions in here.
Okay.
Okay. So you have the way the different pieces slide together, right? That's one invention. You push up the pen as you twist it. You have the ink itself is its separate invention. The colored ink might have different properties if it's blue versus red versus green. They might be separately patentable. You have the viscosity of the ink. How does it roll through the roller ball versus a fountain pen, which delivers the ink in a different way? If you had a click pen, that would be a different invention, how you deliver the pen down. I could keep going on. I'm not that much of a pen aficionado, but you get the idea. So these are all the different ways that you can try to protect whatever it is you're doing.
Okay. So with patents, like when you file a patent, you normally make technical information about the invention publicly available. So, like for example, with the pen, do you have to list everything in the pen that's your pen, or can you keep a trade secret if there's a secret in there?
Oh, that's a great question. Yes. That's something that most people don't realize is that the different forms of intellectual property often overlap, right? So just because I have one product, and I'll go back to the pen, does not mean if I patent it, that's the end of the story. So I can get a patent. Let's say I have a new ink that is 25% more efficient and it lasts 25% longer than all the inks before. So I get a patent on that ink, on that new technology. But maybe there's a specific way to manufacture that ink. And I want to keep that as a trade secret, right? There are other ways to manufacture it. So I can disclose this is one way to make it, this is a different way. But I want to keep one way to manufacture it as my own, that nobody else can reverse engineer. Absolutely, I can keep that as a trade secret. And that gives me now a competitive advantage. Not only that, but my pen, I want to be distinguished from the Bics of the world or the Pilots of the world. So I create a new name for it. Let's call it Everlasting Pens. And I can get a trademark on that name so that if you buy an Everlasting pen, you know it comes from me rather than from Bic. So that's a way that all the different types of intellectual property can overlap to cover the same product.
Wow. That's amazing.
I didn't talk much about copyright because let's face it, it's a product. There's no work of art here. But then again, if I create an advertisement for my pen, that advertisement can be copyrighted.
Okay. And then what's the next one? What is it? Trademarks?
Trademarks. Trademarks would be the brand, the Everlasting Pen.
Okay. So let me ask you this. Could somebody trademark or like their name or patent their name? Or is it just for businesses?
So if you're talking, say, do I want to trademark the name Martin, for example, that's going to be very, very difficult, right? Because the trademark office does not want to say you can stop anybody else named Martin from selling something under their name.
Yeah.
Now, if you add something to it, you could say like Martin's Stupendous Podcast, right? Now you've added some words to it. So it's not just your name, and you have to be able to say that, yes, this is different. I'm still leaving the opportunity for other Martins in the world to practice their own podcasts. This is okay. Might you get that through? You might. Is it a slam dunk? No, but at least you're increasing your chances, right? The more you can do, the more you can show that you're distinguished, you're unique, or you're fanciful. Fanciful meaning something made up rather than just your name. It's Martin's Stupendous. Okay. Yeah. So if somebody else had Martin's Okay Podcast, that would probably be seen as different than Martin's Stupendous Podcast. right? They're not the same brand. It's all a matter of what causes a likelihood of confusion in the mind of the consumer. Would people looking for Martin's Stupendous podcast, finding Martin's okay podcast, think they're the same thing? Probably not. So that's very helpful. Whereas if I had Martin's Stupendid podcast versus Martin's Splendiferous podcast, now we're getting closer. It might be really hard to have one trademark separately than the other because maybe those are things that would cause confusion with each other. It's all about having that brand where whoever the consumer is clearly knows the source of whatever it is you're doing, that it's you. Now, for patents, because you mentioned that, you cannot patent a name, right? A patent is only good for something that is an actual invention, something you've created. The famous Supreme Court case from a long time ago has a line that says, "You can patent anything under the sun made by man." So, Martin, is your name something under the sun made by man? I guess if you really, you could look at it that way. But I see it as something abstract. It's a name. There's nothing really in connection with it. Versus if I create a new widget, I create a new golf ball, I create a new phone. Those are all things I've made, right? They're new ideas, they're new creations. Those are eligible for patents.
Okay, so let me ask you this: can anybody file a patent or a trademark, or do we need to go to like a specialist like yourself to do this? Like, how does that work?
Sure. So technically, anybody can file. Just because you can do something does not mean you should. So I've talked with a lot of clients over the years that have come to me saying, "Hey, I filed my patent application and the patent office won't give me a patent and I don't understand what's happening. Can you help?" So, okay, sure, I can help. So let me see what you filed. And what they did is, they went on the patent office website and looked at what other patents look like. And they just tried to copy that model without understanding what actually goes into it. So maybe they're missing some parts, or they put things in the wrong place, or they need formal drawings to show what their idea is, which is more relevant for, say, a mechanical type invention. And the drawings aren't there. Or they don't know what each different part of the patent application means. So there are two main parts of a patent application. One's called the specification, which is all the description of everything you've done. Here's what's come before. Here's what I've made, and here are all my advantages and what have you. And then there's the second part, which is the most important, which are the claims. And the claims define actually what you protect. That defines your invention. So when you get a patent and you say, "I have patented my new technology," the claims define what you've patented, what that technology is, and what you can stop others from doing. No different than a deed for property tells you the boundaries of your property. The claims tell you the boundaries of your patent. And that's where most individuals get into trouble. They think they know what they're doing, and maybe some of them do to some extent, but they don't know how to write claims in the right format to define what their property is. And usually when somebody comes to me with issues, that's where the issues have come up. And sometimes I can help them. I say, yes, there's enough here for me to work with. And sometimes I have to be honest with them and say, look, there's too many pieces missing. I have to refile this for you to be able to actually get a patent. That's the patent side. The trademark side, I've been working with somebody all year, startup, who has wanted to do as much work as they can on their own, which is fine. I'd much rather them invest their money in their business and come to me once they can afford to do things the right way with me. And I've given him a lot of help. Okay, this is what you need to do to get started, and here are the other things. It was about 2 months ago he came to me and said, look, I'm trying to do as much as I can to file my own trademark application. There are different classes that you can pick, to say what your services are, how the trademark office is going to examine it and what it covers. So I've picked my classes, but I don't know how to describe what I'm doing in the right way. Can you help? Well, honestly, I can give you some pointers, but the only way for you to be sure you're doing it right is to work with me or somebody else like me. Because if you do it on your own, you're probably going to leave things out. And while I like helping people, I very much believe that it's important to give back and to pay things forward. I also have a business I'm running, and I don't give my work away for free, because if I do it once, I'm probably going to be doing it a second time and a third time. And that's going to impact my bottom line too.
Yeah, you have bills to pay.
Exactly. The people that I work with, their salaries aren't going to pay themselves. That's for sure.
So let me ask you this: like, if you, or like, if I file a patent or trademark, or you, like, how long's the process, or does it vary depending on the scope of what's being filed?
Well, how long the process is going to depend on a number of different things. So each type of intellectual property is going to have a different length of time that you're dealing with. So trade secrets, it's all dependent on you. If you want to keep something a trade secret, you implement your trade secret program, protocol, you develop the rules, and you implement it. How long is that going to take you to do it, right? That's not something you register, because if you register a secret, it's no longer a secret,
Yeah.
right? So that's very intuitive that way. For copyrights, they're a little different than patents and trademarks because they're not administered by the Patent and Trademark Office. Copyrights are managed by the Library of Congress. And what you need to do is you basically need to fill out a form, either online or something that you mail in. And you need to send the form. Here's my work of art. Here's my description of it. A few other things, and you send it in. And usually you get something back. Here's your copyright protection within some number of months. Not so bad. And when you talk about doing things on your own, that's the one form of IP I'm most likely to tell people, give it a try yourself. You've created a work of art. Go to the Library of Congress, try to fill out the forms yourself. If you can't do it, I'm happy to help you. I've had people come to me and say, look, I'm very busy. It's worth it to me to pay you just so I don't have to think about it or deal with it. And that I understand also, right? For many of us, time is our most important commodity. You'd gladly pay somebody to not have to think about it. So I get it. But if you want to try to do something on your own, that's where copyrights come in. That's where I think it's most likely. For trademarks are relatively quick compared to patents. You file a trademark application, I'd say 6 months to a year. Most likely you'll get some sort of reaction from the trademark office. And assuming you don't have issues with somebody else with a similar name, a similar logo, you'll probably get your trademark rights, at least your initial trademark rights. And then there are a lot more steps along the way, but you could at least say, yes, I'm registered. I have a trademark. Patents traditionally are what take the longest. And how long it takes from when you file your patent application until you get a patent generally is going to be based on what type of technology you are. So again, if you have something mechanical, a device like a pen, maybe from the time you file to the time you get a patent, you're looking at a year and a half, something like that. If you're talking about something more complicated, like a new pharmaceutical, a new drug, well, now you're looking at 2.5 to 5 years to get that examined in a patent. Yes. 5 years is pretty extreme. I would usually say 2 to 3 as the most likely, but that's still a long time. If you're talking about a new piece of software, now you're talking something that's really time consuming. And there you're looking at 3 to 7 years possibly, versus an electrical invention, which maybe, again, is going to be similar to pharmaceutical. Let's say you have a new display, a new TV or something like that. Maybe that's going to be 1.5 to 3 years. But, and there's a really big but here, there are ways to speed up the process. And something that my firm does that I think we do probably more than any other firm I've talked with is take advantage of a program the patent office has called Track One, where if you pay them an extra fee, just an extra government fee, they'll guarantee you get through the process within 1 year.
Wow.
Think about that. I'm talking about things taking 2 years, 3 years, 5 years, 7 years. That's a really long time. If the patent is really critical to your business and you need to know quickly, do I get a patent or not? This is the way to go. You pay the extra government fee, which, by the way, depending on your size, might not be so expensive. If you're a really, really small company, it can be as little as $1,000. And you'll know within 1 year, do I get a patent or not?
So it's important to file as early as possible.
Absolutely. You want to file as early as possible for a variety of reasons. Depending on your business, you might need to have that patent to protect your markets, and you might be able to get out to market quickly. And if you can and you want to have that protection, yes, it's worth it to file quickly. Also, if you're interested in protection not only in the US but around the world, there are certain timelines you have to meet to protect your invention elsewhere. Most of them start at 1 year. So it's really valuable to know within that 1 year, hey, does the US Patent Office think this is patentable? And they'll give me a patent before I spend significant money going elsewhere around the world.
Wow, that's amazing. Like, I know we're running short on time. Is there anything else you'd like to add for IP?
Quite honestly, the other thing I'll add, and this again gets to the timing, you have to take each piece of IP separate. So just because you think you know the rules and the laws around one piece does not necessarily mean you know it around everything. For a trademark rights actually really only start once you start using it. Think about your mark. Coca-Cola. They didn't technically have any real rights until they started selling something with the Coca-Cola name. Otherwise, it's what's called an intent to use, and it's like a reservation. I make the reservation that I will be using this name in the future, but I do not have my full rights until I start selling. Versus patents, where if you disclose it, you make it available to the public before you file your patent application, that early disclosure might prevent you from being able to get a patent on it because you're seen as having donated it to the public. Now, in the US, you have a 1 year time period. I published it. I now have 1 year to file my patent application, and I'm still okay, most likely. But that's the US. Most of the rest of the world, if you have a publication out there, you're out of luck. There's not a whole lot you can do. So the earlier you talk with somebody, with an expert, the better off you are.
Okay, so that reservation to use the name Coca-Cola, do
Yes.
they have 1 year to start using it, or is there a set time frame, or is it just for life? Like I could do it, and then it doesn't matter if I do it today or 10 years time, it's still mine.
It's still yours, but if somebody comes around in between when you file that intent to use application before you start using it, you have a fight on your hands now because they're actually using it even though you've made a reservation. And trademark rights depend on use.
Yeah.
So now you have a fight. Now you really have to see, okay, what are the facts of the situation? What goes into it? And it becomes less clear.
Okay, that's awesome. Well, I really appreciate you taking the time to speak with us today about what is IP and how to understand it. For me, it's been fascinating to learn the different ways. I hope everyone else has enjoyed listening to this. And in the next episode, we'll cover what are the requirements for each form of IP. Joshua, thank you so much. It's been an absolute pleasure.
I've enjoyed being here, Martin. Thanks so much for having me on.
All right, stay safe. Bye-bye.
You too. Bye.